Shall we get started? Since we are, I think we actually have some audience as well. So we're delighted to have you all here for the first of our evening programs sponsored by the Center for Technology, Innovation and Competition. For those of you who've not had a chance to meet me, I'm Christopher Yu. I am, the director and the co-director along with Polk right now of the center. We are delighted to welcome you here in the first of what we think will be an exciting set of programming. A couple of disclaimers just for in the age we live in. This is being recorded, so everyone should be aware that that anything you say will be picked up. In addition, it is being offered for CLE, and we will be sharing CLE passwords multiple times during the event. And I gather, Carla, we're doing that online, I guess? No one's given me...
You do not have to do passwords today.
I do not have to do passwords, okay.
Probably aren't a lot of CLE takers here.
Well, there are some.
Virtually.
There are some.
Right?
Virtually, there's more. And so there is a virtual audience, so there are other people participating who you will not see. Just no virtual audience. Erase that. And, okay. And you
He's getting passwords. What's going on here?
All right. The other thing I should say before we get started is we should give our great thanks to our co-sponsors for this event, the Entertainment and Sports Law Society, the Internet Technology and Society Collective, the Penn Carey Law Antitrust Association, and the Penn Intellectual Property Group. Fantastic student organizations, all great partners with CTIC both ways. We're delighted to have them as our partners in this event and in almost everything we do. And we hope that you will join all those organizations because I think they're an integral part of the experience here. All right. Without that further ado, our goal is to introduce you to a bunch of issues that are what's hot right now in law and technology. And I'll be honest, we can't even fit in the time we have all the things that we could talk about, not the least of which I was just flipping through my own inbox and realizing that they set two of the arguments on about how Social Media First Amendment Act is set for October 31st for oral argument. And so I'm sure we'll have further things to come. And just to wet your whistle, it's not just these. We have two immediately upcoming events. On October 11th, our own Jennifer Rothman will be appearing in an event we're co-sponsoring with the Institute for Law and Economics on emerging issues on name, image, and likeness, which is one of those very hot things right now. If anyone knows anything about the fight over the estate of Michael Jackson or all the college sports athletes selling their images to different people, it's an incredibly important issue. I'm not even touching on the big things. And I'm delighted to announce that just yesterday, we actually finalized on October 10th. Federal Trade Commission Chair Lina Khan will be coming to give an address at 4:30. And her goal actually is to interact with students. And so there will be ample time for question and answer and a reception afterwards. So if this is, for those of you who happen to think antitrust law is hot right now or maybe interesting and how issues with big tech are, also if you didn't notice, it was announced today that the Federal Trade Commission that she leads brought their long-awaited suit against Amazon. And so if you need further proof that these are hot and interesting times to be into talking with Chair Khan, I don't know what to tell you, but I would encourage you to come to our event on October 10th. All right? Well, we're delighted to have you here. And this is always our kickoff event for the year to really look forward to the year. We have 5 fantastic speakers. On my immediate right, Polk Wagner, the Michael A. Fitz Professor of Law, expert in intellectual property, particularly patent law, and also really studying how AI is transforming legal education and practice right now, and a great pioneer in online learning. I apologize in advance. I cannot list all your accolades, but that will do as a headline. Next to her is Jennifer Rothman, the Nicholas F. Galicchio Professor of Law, expert in also in IP and policy, trademarks and foreign competition, and probably the world's leading authority on rights of publicity and name, image, likeness, First Amendment scholar, copyright scholar, and many other things. Gideon Parchamovsky, Robert G. Fuller Professor of Law, specializing in intellectual property, property law, cyber law, from traditionally a law and economics perspective, but branching out into such things as corporate law, evidence, and other things as well.
Number one in my family.
Yeah, there you go.
There are only 3 people, so.
So you're in the top 3 anyway.
Should we ask your wife to verify that? To Gideon's right is Herb Hovenkamp, the James G. Dinan University professor, Penn Integrates Knowledge professor, considered the dean of U.S. antitrust law, also an expert in IP torts and American legal history. And to the far right, Cindy Dahl, who's somehow I managed not to bring, so I'll have to wing this one. The director of the Detkin Technology and Intellectual Property Law Clinic.
Close, good.
Intellectual Property and Technology Law Clinic. Also a leader of many student programs that we do, including people, including a number of the externships that we do in parallel with other schools, and is really an instrumental part of everything we do, certainly from an experiential learning standpoint. She is the maven of all that we do. All right? We have agreed in advance to talk about a number of issues, and then we'll open up to the floor. I'll have each one of the faculty introduce one of the issues, then ask any other faculty members who have other additional comments to offer them at that point as we go through it, and then we'll go open up to the floor for question and answers at the end. All right, Gideon, let's start talking about the big copyright decision from last term, Warhol, where we've asked, were the additional images, were they transformative? Was it fair use?
Great. So according to the majority, it was a 7-2 decision. The answer is no fair use. Now, what is super interesting about this decision, and I would encourage you to read that. That would be the only thing I would encourage you to do, is to read Justice Kagan's dissent. I've never read anything like that.
For the benefit of those who haven't read the case,
Yeah.
what was the
Sure. No,
image issue?
I'm getting there, but it's the only Supreme Court decision ever where you have reproductions of artworks from different periods. Even in lower review articles, you will not see many such things. So basically, the cert was granted only on the first factor. I assume that people here are familiar with the fair use doctrine. So, and Christopher is helping to zoom us in. The nature of the use. And the majority basically focused on the transformativeness of the use, but even more so the commercial nature of the use. And that was its ultimate decision, that because the work was used for licensing purposes, it was a commercial use and therefore no fair use. The dissent, Justice Kagan and Chief Justice Roberts, but primarily, of course, Justice Kagan, she focused on the artistic merit of the work and not whether or not it was done for licensing purposes. So the majority of the dissent defined the term use very, very differently. She accused the majority of not understanding art. The majority disagreed. And this is really, this was, an accident waiting to happen. Legal experts write about art. There is no way out. This case, for those of you who hope that it would make everything clear for us, didn't do that. Many commentators believe that the decision simply set us back. And I think my time is up. So the work is not transformative per the majority, no fair use in the Andy Warhol case, as the Second Circuit ruled to. Thank you.
All right. I'm going to pull up the image just so everyone sees what it is for fun. So Gideon, we have the Supreme Court's decision. Have you learned anything since that's been decided about how this is being received by courts, or does anyone know? Is this been?
So it's very, very interesting. Most commentators actually focus on the unusual exchange between Justice Sotomayor and Justice Kagan. And if you're interested in that stuff, you will find it on many of the blogs. And I think that what is really interesting here is the fact that it was all about Andy Warhol and his style. And maybe Jennifer, you would like to talk more about that. Warhol was the master of making minimal alterations, and his touches pretty much changed everything. Now, let's be honest. A lot of us could have done that, but none of us is Andy Warhol. And because it was Andy Warhol, we, or at least Justice Kagan, tended to treat the work very, very differently. But if there is a takeaway, and I think that's what is of interest to you guys, it is that you need more than minimal transformations. I mean, even minimal transformations by Andy Warhol will not do. Prior to this case, the transformation could be in the meaning. And I think there is a transformation in the meaning. But after this decision, I would encourage you when you represent clients to require more than just a transformation in the meaning. Some addition to the content, to the substance of the work will be a safer place to stop.
Jennifer, you've written, Professor Rothman, you've written on Warhol as well.
Yeah, so I have lots of thoughts, but so just tell me when I should stop sharing my thoughts. So a few things. So I think that the facts of the case are really unique and worth highlighting for going forward. And I think we have no idea, frankly, how influential this case will be at this juncture. And the reason for that is that we could really narrow this case to its facts. And not just that Andy Warhol is a superstar, because this sort of came out against the Andy Warhol Foundation, but that in this instance, both uses and the majority's decision was limited to a use of this picture of Prince to illustrate a magazine about Prince. And I think that's really, really important because the original photograph, which is on the left, which was taken by Eileen Goldsmith, was also initially used to illustrate a magazine story about Prince. And then this entire Prince series by Warhol was created, it was commissioned by a magazine to illustrate a story about Prince. And it was, and Eileen Goldsmith's photograph was licensed for use in the original Warhol portrait that was printed in the magazine story about Prince. So I think here, and if you listen to oral arguments in the case, it was pretty clear to me that Goldsmith the photographer was going to win because of those very specific facts. They just didn't understand how you could use an image of the same person taken from the photograph, whether colored or not, for the same purpose. And that's the transformativeness piece that's really highlighted in this case, that if you are using essentially the same work for the same purpose, it's not transformative, even if you change the framing, even if you add some colors. But they expressly did not rule at all about the artwork in museums or prints, not prints, but prints, art prints, or posters that you could get of the Warhols. And I think that leaves a lot of stones unturned in terms of what this case is going to mean when we don't have a substitutionary use and when we're dealing with pure art uses. So just a few other things that I'll flag and then I'll pass the baton, which is that this case really collapses to some extent the fair use factors, factor 1 and factor 4, because factor 4 is about market harm. And so does a defendant's use of a copyrighted work disrupt or harm the market for the original work, including licensing uses? And here, and factor 1 is about whether it's for a different purpose or use. And the court has read in transformativeness there. And here, the court sort of bootstrapped the market harm factor into determining whether it was transformative or not. So I think, again, that's another thing. We're going to have to see over time how that collapse evolves, if it's going to stay collapsed or if we'll try to get more differentiation. And I think maybe just the third thing I would flag is that this case, and one reason that I thought it would come out this way, other than just it being about protecting photographers and their economic interests as artists, was about the derivative works right, which itself says that in order to be protected as a derivative work, as a copyright needs to transform the underlying work. And so I think the court also, the majority in particular, and there was a amicus brief on this, focused on what could transformativeness mean if it's not just creating a derivative work that should also be owned by the original copyright holder. And if that's all this is creating a derivative work for the very same purpose, the court said that's not protected.
So I remember being taught when I was a student, the judge that renders a decision doesn't ultimately get to decide what it means. It's the future judges. Any handicapping on what do you think? Is this going to completely change? Is it going to be a small, fact-limited decision that's not that influential, or is it going to completely revolutionize how we think about transformative use? Or something in between?
I'm going to say, neither. Something in between. I don't think it's going to revolutionize things because I think there's some pretty safe, determined understandings of fair use that courts are going to be hesitant to upset. But I think it may have a real shift in influence in certain types of art that take other art and work from it. And I think photographers as a group will view this as a big victory and try to be asserting their rights much more dramatically. And I think those who make collages and use sort of the appropriation art movement, I think is really going to struggle to find out what are safe in this context. And they may err on the side of licensing in instances in which it's not prohibitively expensive.
I mean, the real question is whether or not those facts are, how limiting those facts are to the holding. Because if you think of the holding and its emphasis on substitute uses, and you say that it sort of collapses factors 1 and 4. I actually read it more as almost advancing factor 4 over factor 1, right? So if you have a market substitution, you cannot then be transformative, right? But the question is, does that apply outside of this specific case where you're using, the allegedly infringing work in a sort of substitution sort of way? If it doesn't, then I think you're right. Then it's a big victory for particularly photography, right? Where you're going to get a lot of works that look really similar that are adapted. And if you're not so concerned about substitutive uses, then it looks like fair use is going to be harder to come by. On the other hand, if it's really just about substitution, then you can really sort of limit this to its facts.
So just to add to that, I also felt that we're throw back to 1985, Harper and Row versus the Nation, right? And I see that my colleagues are nodding. All of a sudden, whether the use is commercial or not carries a lot of weight. I'm somewhere in the middle. I think that, like, for several years now, I had at least a sense that it was getting progressively easier to argue transformativeness. And I feel that Supreme Court now put its foot down and said, okay, this is as far as we go. Now, whether or not we're going to go back a lot, I'm not sure. But I think that the Supreme Court understood is that, look, if any minimal change would count as transformative, and it's true, certainly both of you are right about photographers, but no one will ever buy a license if all I need to do is just change the work a little and then it's fair use. No one would pay copyright owners for their works or their rights.
Well, we could go on like this, and do you have Jennifer?
I was just wondering if Cindy had anything, because you wrote something about.
Yeah, I do. Many of the things that you've already discussed are things that I've been thinking about as well. And then I think one other, we used to be able to sort of give guidance that if there was a technological impact or a technological change, that was much more of a transformative use. And I think this was interesting because it was exactly, a substitute. It's very easy to say that there was market harm here because it was an exact substitute for what had come before. But I think, it's interesting to sort of see now what the line is going to be. You maybe don't have to go as far as the technological change.
Especially because the last big case was a big tech case, which is Oracle versus Google. Trying to put these two together is the big question.
Right.
We could, in fact, there are a whole symposium on this. We could go on and on, but just to push us along, we have another fascinating case, which is the Jack Daniels case. And we have Professor Wagner here to talk about it, including props.
So many of you may know that Jack Daniels makes a brand of whiskey.
Really?
And they have what I think can safely be described as a
I by mistake bought the toy instead of
very well established trademark in that area, both the word and as well as we will see the bottle and the logo. Enterprising companies have created dog toys. This is the Bad Spaniel dog toy.
My neighbor's dog's favorite toy, by the way.
Oh, really?
Yeah.
Does it also work for kids?
Toy.
Yeah, maybe. So they've done this across a variety of major trademarks and brands. And so Jack Daniels did not find this amusing. And so they sued. And the question that went to the Supreme Court, a couple of questions, but in general, the question is can you be liable for using a trademark in either trademark infringement or trademark dilution when it doesn't appear that you are actually substituting. They're not claiming that this is Jack Daniel's whiskey or in fact that it's associated with the whiskey in any way. It's clearly a separate product, clearly in a separate category of products entirely. And for a long time, the case law has been relatively clear that in issues like this, where it's primarily a parody, that we thought typically that these would not be infringing. Interestingly enough, there's a series of dog toy cases where in years past, dog toys using major trademarks have been found to not be infringing. So the Supreme Court in June, one of its final cases of the term, changed that and did indeed hold that this was an infringing article. So this is now officially a illegal article to have. I got it off of Amazon just before the case.
Not to have, just to sell.
Just to sell, and still have. And in doing so, the court did a couple of interesting things that I think we don't really know yet what the ramifications are. First, the Second Circuit, with respect to trademark infringement, has established for many years what we all know and love as the Rogers test, the Rogers versus Grimaldi case. That test is generally, paraphrasing here, says that if the First Amendment is implicated, if there's some sort of expressive use of a trademark, then unless that expressive use appears to be some sort of pretext for otherwise ripping off the goodwill of the trademark, in general, trademark infringement can't go forward. That's an important holding because that means a lot of sort of parodies don't even make it past the summary judgment stage. You don't have to go to full litigation to decide whether there's been harm and how much harm and things like that. The issue is if you just simply say, I'm making a First Amendment based or a expressive use, that would be non-infringing. The Supreme Court says, nope, the Rogers test, they don't necessarily overrule the Rogers test, I don't think, but they say it cannot be used where you are making use of the mark on your own products. You're making essentially your own use of the mark, right? This represents a product, the Bad Spaniels mark, this sort of shape of the bottle, represents its own product. And so there the court says the Rogers test does not apply. Similarly, the Ninth Circuit with respect to trademark dilution has had an interpretation of the dilution statutes for about 20, 25 years, whereby a parody use was a non-commercial use. So if you were making a parody of something, even if you were doing it in a commercial sense, the court decided, well, that's what was meant by non-commercial, right? So you are essentially, again, immunized from liability if you are making a parody use. The Supreme Court says, the Ninth Circuit is not interpreting the statute correctly. That is not what it means. And again, that part of the statute also says that if you are using the mark in a way that represents your own goods, you cannot avail yourself of that non-commercial use exception. So in both cases, the court sort of seems to close the door on a parody defense for at least commercial items. They're careful to sort of limit themselves to cases where you're using it as your own mark. I think a lot of questions remain about this case as to what the true scope of it is. Is it really going to be significant? Because a lot of, what do we think of in terms of commercial uses? Does it mean anything that makes money, or is it just anything that affects the market in some way, in which case it could really dramatically diminish the ability of people to make parody uses of well-known brands. So I'll stop there.
Would you infer from this, does it have any impact at all on the use of a competitor's mark in comparative advertising? If I'm GM and I use Toyota's.
Yeah, that's an interesting question. I'd be interested in what Professor Rothman thinks there. My read of it is this was really just directed primarily at sort of these parody type uses, right? Where this was, I mean, they're clearly not making any comparative judgment here, right? And that those are probably still, and they're really talking about both the Rogers case, which wouldn't apply to comparative advertising, and the non-commercial use exception and to dilution, which would again not really apply to advertising. So I don't think so, but I think there's a lot of uncertainty about how broadly this case is going to be read by lower courts.
Well, but for the sake of our audience, I mean, the Supreme Court could have modified their infringement analysis and dilution analysis to incorporate the fact that it's a parody. I mean, even if you shy away from the full, perhaps, protection that we should afford parodies, why, in your opinion, the court did not go there at least? Our customers really confused. I mean, you have to drink a lot of Jack Daniels to understand that this is not your whiskey.
I mean,
it happened
you
to
know,
me, but
it's an interesting question. I think that in this case, Jack Daniels told a pretty compelling story to the justices saying, look, this entire product, and indeed they have a whole line of products that are very similar to this, is solely piggybacking on all of the hard work we've done to market and generate, you know, enormous amounts of value in our trademarks. Like this, there's nothing to this other than the fact that they're taking our mark and adapting it for their own use, and we should be able to either control that, maybe license it, or something like that. And I think they told that story, and the justices essentially said, you know what, that makes sense to us, and they, you know, went to do that. I agree with you, they could have drawn their decision much more narrowly, and they did not.
So just a very quick follow-up, again, for the sake of our audience. You know, what you said is 100% correct, no argument, but it's also true for transformative uses in copyright. So I know that it's not the same test, but one could have made the argument that it's not harming Jack Daniels in any way or form. So it's it actually can get people to buy Jack Daniels here.
Yeah.
Here's a bad spaniel for my dog.
It is hurting Jack Daniels, and that's the point, right? So, right, it says bad spaniels are the old number 2, which is a reference to defecation, and then on your Tennessee carpet. So now when you think of Jack Daniels, which frankly is mediocre whiskey, then you will also think of defecation, which will reduce the value of the brand because now you have an unpleasant association with it. And just to get back to Herb's point, it's not going to affect comparative advertising at all. Because here, right, not only is this not a comparative advertisement, but the court limited its decision to use as a mark, which it is Bad Spaniels, and it's on the label here, Bad Spaniels as well. So they're using it to name a commercial product. And then in a way, we'll get back to this tarnishing thing. You know, there's no real conversation here where we're saying this product is better than another. So for my trademark students have heard me talk about this, but my First Amendment students, right, what is this saying in public discourse? Like, what is it saying about Jack Daniels? And it's just saying we're making fun of Jack Daniels. And that's not the most compelling free speech argument. And I'll let you have the prop back. But, right, so I think there's some important distinctions here and some open questions. So I would probably highlight the most important aspect of Jack Daniels is a suggestion that dilution law is constitutional, right, and survives First Amendment scrutiny. And a lot of First Amendment scholars and I think IP scholars were hoping or thought or argued that dilution law itself is not constitutional because what Herb said, which is it's not, and Gideon said it's not confusing, right? No one thinks that Jack Daniels is selling the squeaky toy because it is a negative portrayal and it's sort of making fun. And so the question is, can you limit even this non-confusing speech? And some said, no, that violates the First Amendment. I think the Supreme Court came down pretty clearly in Jack Daniels. That is not protected by the First Amendment, which further shores up a whole line of cases in which intellectual property rights trump First Amendment speech protections. And I think this is just part of that story. I think the second piece here is sort of the open question of whether the Rogers test is going to survive. And the Rogers test has been very successful, and a lot of people, and I considered writing a amicus brief in this case and then decided that the Motion Picture Association sort of had it covered. But the Motion Picture Association was very worried, did file an amicus brief here and said, whatever you do, don't get rid of the Rogers test because it for decades has protected motion pictures, plays, books, and allowed them to reference commercial products and other people's trademarks, and it's worked well. So the big question is, will this unsettle that? And the Supreme Court punted on deciding whether the Rogers test applied to works of expression, although they didn't distinguish, which is part of the problem with the Rogers test, what is an expressive work or an artistic work as opposed to this? Some people think this is artistic. How do we differentiate? So I think that's going to be one of the big questions. Does Rogers survive? Can we make meaningful distinctions between works of expression and what are deemed commercial products? I think another sort of open question that this case raises for me is whether this is even speech. And the Supreme Court also punted on that question. And after the Ninth Circuit decision, which held that this was speech, and was protected by the First Amendment, one of the very first blog posts about it was a Christian right legal organization saying this will help us in our cases with those who don't want to sell cakes and wedding stationery, etc., to same-sex couples for their weddings. Because if this is speech, so is our cake. And so it may be, right, that's part of the distinctions we're going to be making. And I think the fallout from that decision will also be something that I'm certainly keeping track of. And one final thought, just with regard to the other case, the Fourth Circuit case involving Chewy Vuitton, another pet toy, which made fun of Louis Vuitton with a little bag. That was also a dilution case. But dilution, and now the Supreme Court mostly traveled in First Amendment land. But if we shift to trademark land, Chewy Vuitton was a case about dilution, which is the diminishment of the value of the trademark without regard to confusion. But there are two types. And there's dilution by blurring, where people have multiple associations, and that might reduce the value. And the other is tarnishing, making it look bad, right? Thinking about defecation while thinking of Jack Daniels. So that's tarnishment. So the Chewy Vuitton case was solely about blurring. And the court said when you are making a parody use, rather than blurring and having multiple associations, you're actually distinguishing the two goods. So people are, rather than it reducing the value, it may actually be increasing the value and distinction of the brand name Louis Vuitton when you think of Chewy Vuitton, rather than having this tarnishing effect. There was no tarnishing claim. Well, there was a tarnishing claim in Chewy Vuitton, but it was that dogs might choke on the toys, and there was no evidence of that in the record. This is very different because of their tarnishment claim. So I think going forward, it's not even a sky is falling for dog parody toys, because I think the blurring ones may still survive review.
But will it? I mean, if they were to erase the number 2?
Well, there's other things about it. They're saying it's like 40% poo. I mean, there's a whole bunch of other things that are in there.
Yeah,
Sure.
there's a bunch of description on it that's
But
allegedly
we can
tarnished.
eliminate it, and then it will survive.
No, we're not
But then
going
it
there.
becomes
All
less of
right.
a parody though, right? Then it becomes less of a parody. Like if you take all the other things out, then it becomes just a dog toy that has.
Oh, we still have the Bad Daniels, the Bad Spaniels.
Oh, okay. But
We will return to these themes when we come back to the Ulster case at the end. But let me push us along and let's bring Herb Hovenkamp in, if we would. Professor Hovenkamp, so I was thinking, this has been a pretty eventful year for antitrust. We have new merger guidelines. I was thinking this would be the big news, and then we get the big Google cases going on for a couple of weeks about their search stuff. And then I thought the big news today is going to be Lena Khan coming to the University of Pennsylvania. And then the FTC drops its big case. So, I mean, let's just say we have ample things to discuss with you. Take whatever direction you like, and we'd love to hear from you.
Yeah, several things I'm not going to be talking about. Things Christopher just listed, as well as the Epic Games case that is sitting on the Supreme Court's docket, and which involves a nationwide injunction under state law in conflict with federal antitrust law. That's a big, big issue in antitrust administration. And of course, the Google trial. But the Amazon complaint was filed this afternoon. It's moderately lengthy. It's not the longest of the tech platform complaints, but it's 150 pages or so. So I barely managed to get through it and took down a few high points. Number one, there is no specific request for a breakup. That's important, at least at the rhetorical level, because a lot of people kind of associate the neo-Brandeisians and their attitudes towards big tech with requests for a breakup. It does have the usual equity boilerplate in it that requests for permanent equitable relief, not limited to structural relief, but there's no request for a specific breakup the way there was in the Facebook case where the FTC specifically asked that two subsidiaries, Instagram and WhatsApp, be divested. And frankly, the types of conduct alleged here, assuming they are found to be illegal, are not the kinds that would normally result in a breakup. There are also no per se violations alleged, no price fixing or concerted refusals to deal. And as a result, these are all market power offenses. If you are proceeding under the rule of reason in antitrust, you have to establish market power. And in order to do that conventionally, you have to define a relevant market. Well, that's a big problem for a company like Amazon because it makes so many different products, and market power attaches to products, not to firms. So the way the FTC gets around that is it alleges that there is a market for online superstores. Now, is that rational? Well, yeah, we have a theory called cluster markets, which says in certain cases you can group non-competing products together into a single market for evaluation purposes, the most common one being hospitals, right? A hospital does obstetrics and anesthesiology, thoracic surgery, lots of other things. Nevertheless, we do speak about a market for hospitals, and they generally have two requirements. One is that it's convenient for customers to get them all from the same place, and the other one is that it's hard to replicate. And so I think the FTC is going to have kind of an uphill battle establishing that there is a cluster market. Several courts have held in the past that the simple fact that a big department store sells multiple products does not mean that that's a cluster market if a customer can freely buy a single product at, say, Walmart, but then go across the street to Susie's hardware store and get the same product over there. So we'll have to see how that works out. There are no allegations of predatory pricing. That's one of the claims that Lena Kahn made in her Yale Law Journal note that kind of got her started. Predatory pricing is not asserted here. There is a claim of a tying arrangement. That's when you anti-competitively tie two or more different products or services together. In fact, there are a couple of different tying claims. One is the tying of Prime and Amazon fulfillment services. Okay, now what does that mean? Well, Prime is a special category of things that you can purchase. You can be an Amazon Prime customer, and if a product is covered by Amazon Prime, then you usually get free shipping and you get pretty quick turnaround. In fact, a lot of Amazon products, you click on it today and it's at your front door by tomorrow. That's a special feature of Amazon Prime. However, Amazon only gives Prime according to the complaint. If you also agree to Amazon fulfillment services, which basically means that Amazon gets to process your claim and take care of delivery. Now, these are idiosyncratic tying arrangement cases in my view, because these are things that stores do all the time. That is to say, if you want to buy something at Macy's and Macy's says, well, we deliver our own product, it's not a tying arrangement if Macy's simply refuses to let independent carriers deliver that product as well. So that's going to have to be litigated. The other tying claim pertains to the grouping of products within Prime. That is to say, once you sign up for Prime, you get basically entree into a collection of products that are available on Prime. Those are the ones with the fast shipping and so on. You also get Prime Music, which is a music streaming feature, and Prime Video. And the other objection is that if you subscribe to Prime, you get all of these things, and Amazon will not permit you to buy a subset. That is to say, you can't say, I would like to have Prime Music. I really don't care about Prime for videos or other kinds of arrangements. It states it in some peculiar ways. This is a short quote, and then I'll shut up here. But paragraph 220 says, while Amazon technically offers Prime Video on a standalone basis, it successfully uses dark patterns and other manipulative design techniques to thwart most shoppers from actually being able to sign up for it. That's a bit of a departure from tying law, which usually requires absolute, I don't even know what a dark pattern is on Amazon, and it's not defined in the complaint, but the idea that you can only get one product if you agree to a second product as well. So, my off-the-cuff assessment, and this is on a very quick reading, is that FTC's got some battles ahead of it in this particular case. There's a lot alleged. I think these are the most important things.
So I'm fascinated. So a whole bunch of things I'd love to ask you about, but let's take one of the most simplest ones. They're tying their fulfillment services and their actual e-commerce. So are they arguing that they're hurting other e-commerce platforms by having their own special dedicated fulfillment,
Yes.
or are they hurting fulfillment? I mean,
They're hurting other downstream services.
because they're able to provide a higher level value of fulfillment services.
There's a lot of similar arguments in this one to the Google case, which is that Amazon is using scale to undercut smaller rivals. And that's just along the lines that you're suggesting.
But you have to then ask, could the other rivals, is the US Postal Service enough? Could they band together to create, to partner with, say, UPS or another fulfillment service? It's an interesting question. What are they alleging that makes this so particularly bad? That's Amazon has scale that no one else can achieve?
Yeah, that's part of it. Part of it is that they are doing this at a scale no one else can achieve. And part of it is kind of, I don't want to overread it, but it's kind of the notion that you've got a duty to distribute your products in a way that makes fair space for others if you are very large. I mean, this whole idea that by default, sellers provide their own delivery if they want, or they contract it out to third parties. Is it really anti-competitive to insist that we deliver our own products? Amazon's already stated in a press release that the reason Prime works is because it has very tight control over delivery times. We have to deliver our own stuff to guarantee that it gets out of there. Apple has used that defense successfully several times now with respect to claims that it won't permit third parties to sell apps on the iPhone. It's a quality control mechanism. So that's going to be litigated. I don't know what the answer is, but Amazon is basically saying we need to protect the integrity of Prime as a mechanism that gets this stuff to customers the way we are promising it. And the only way we can guarantee that is if we take care of fulfillment. Fulfillment means more than delivery. It means typically storage or inventorying, packaging, and then delivering and taking care and processing the transaction. That's the range of services called fulfillment. And Amazon is saying we need to do our own fulfillment if if we're gonna offer these products on Prime. Or one other claim that's related to this, which Amazon disputes, which is you can't get into the buy box, according to the complaint, unless, if you are offering lower prices on a different website. Now, the buy box is that little box, when you do a search on Amazon, up in the upper right corner, you get a price, and I think more than 90% of customers click on the buy box. But then if you look down the page a little bit, you'll see something like other sellers, and you can click down there, and then there'll be alternative sellers at different price points, different shipping points or speeds, and so on. The buy box, so nobody is forced to accept the buy box, but most people do. And one of the items in the complaint is that in order to get into the buy box, you cannot be offering a significantly lower price on another website.
Gideon, you want to say something?
Yeah, so it's a fascinating question for Herb and you, but more generally, so what would be the cost of defending the case for a company like Amazon, and also what's the end goal? I mean, so the idea is that it will destabilize Amazon enough so that other competitors can enter the space and be more effective in competing with Amazon or in Google, or what are we trying to get at the end, you think?
Well, I think what they're trying to get at is more competition in distribution of Amazon's own sales, okay? And secondly, these are a most favored nation agreement is an agreement that you may not charge a lower price on another website. There aren't any of those left anymore, and the complaint doesn't allege any. And so it's alleging these things with respect to like the buy box. In order to get the buy box, you cannot be selling something at a lower price elsewhere. Presumably with that removed, then that particular merchant would be free to charge any price it wants at a lower store. One allegation of the complaint commits what is widely thought to be an economic fallacy, which is the idea that because it's so costly for third-party merchants to sell through Amazon because of these constraints, that they're forced to charge higher prices elsewhere. Well, the conventional wisdom, which is, I think, pretty robust, is that you charge a profit maximizing price on each individual site where you sell things, and you can't simply raise your price, can't simply raise your Chicago price to compensate for lower prices in Philadelphia because you're already charging your profit maximizing price in Chicago, and you're going to make less money rather than more. So I'm sure Amazon's going to have its experts litigating about that as well.
What do you want to say?
Yeah, so I mean, one of the things is the first I've heard of the details of the complaint, although obviously there's been sort of this noise going on for a while, is I'm struck by sort of, in a sense, how modest the claims are, right? I mean, as you noted in the outset, the remedies for the behaviors that they are alleging here are things like, well, you gotta, unbundle Prime maybe, or
Very conventional
you gotta
injunctive remedies
let
in
people,
antitrust.
use other fulfillment services and be in the Prime program, right? I mean, these are very minor sort of changes, and you sort of think about sort of the magnitude that at least is alleged of the damage that Amazon has done to, small town stores across the country, and you think, wow, this is really a pretty minimal impact. And maybe it's just because antitrust doesn't solve, for that problem, but it's interesting, it's striking to me that, with all of sort of this noise about how Amazon is sort of destroying, small town America, this is pretty minor, right? Like, really?
There is
I
going to
can
be a
buy
lot of
Prime
literature about it. I mean, this
video?
complaint is so fresh right now, but I mean, Lena Khan made her career on a student note. Would that we could do that? It's entitled Amazon's Antitrust Paradox. and it's in the Yale Law Journal. It's 10 or 15 years old now, but based on that, entire books have been written about the need to break up Amazon and everything. And this is a very thin complaint asking for the most conventional conservative types of relief in antitrust, which are injunctions. Stop doing this, that's it. So we'll see.
And it would be for the benefit of other online retailers, not these small stores in rural areas.
Right, it's not gonna impact that at all,
Yeah.
right?
Do you have a sense of why it's so narrow? I mean, if there are books written with a playbook and a roadmap about more.
Well, because I don't think they're able to come up with a credible violation that requires a breakup. With the Facebook case, it's a little easier because Zuckerberg made, I think, a strategic error when he acquired Instagram in particular and did not merge it into the Facebook platform. So now it is a separately held subsidiary. And as a result, you can break it off without doing very much damage. And furthermore, spinning off an acquired asset is a pretty conventional antitrust merger remedy. Breaking up Amazon, which is very largely, not exclusively, but very largely internally developed. I mean, how would you do it? You could force it to divest Whole Foods, but
You could
Amazon's
say
market
that
share of groceries
Amazon
is
Web
2.5%.
Services, right? I mean, they make a lot,
You could,
right?
yes, you
Web
could
services
force
or
them
something.
to divest web services, but what market would you be making more competitive?
Right.
You'd just be selling a dominant product to someone else. There's no value in divesting Amazon Prime. The Prime market right now, Amazon streaming, video streaming, that market is robustly competitive. Market shares keep changing all the time. Netflix and Amazon each have about 20%. And then you've got Max and Disney Plus and a few others. So nobody expects a competitive improvement from a divestiture there. And music, Amazon is an also-ran. By far the biggest music seller is Spotify. And then Apple Music and Amazon are both pretty distant second. So, I don't see any competitive gain from breaking up Amazon. Courts have the power to do it, but, doing it in a way that increases output and reduces prices or produces better products is not very easy.
Plus, as you said, there are less dramatic remedies here that can address.
They're very conventional
very
remedies.
conventional
Yeah.
remedies, yeah.
So actually, that's a nice segue talking about the online world to bring Professor Rothman into this conversation. In particular, one of the things we were poised to talk about is the writer's strike, the role of AI and the law, and these different things. And lo and behold, we have another development here. The writer's strike is settled.
Yeah.
Big news.
It's not officially settled.
On
but it's very close to being over. There's an agreement on talking points. But actually, it's a great transition from Amazon, some discussion of Apple, to the writer's strike and the actor's strike, and we'll circle back to AI as part of that. But I think understanding the economy that's going on with content creators and distributors right now is really important backdrop. So when the streaming services started, or maybe we go one further step back, which is some creatives in the film and entertainment industry, TV industry, get residuals for the work they do. So particularly directors, actors, and writers. So they'll do something, they'll get paid, but then they'll get paid again. And in the traditional TV model is probably the easiest way to understand this, right? So you have your first run show, people would get paid, then you'd have reruns. People would get paid when it reran. You'd get paid when it ran a third time, a fourth time, etc. You'd get more money. These were called residuals. You would also get a bonus if it wound up being syndicated, which meant it ran for more than 5 years. You would get paid if it aired in a movie. You would get paid if it aired on cable. All of these things were residual payments. Streaming services came on. The streaming services said, we don't even know if we'll get any money with our streaming services. So initially there were no residuals. Then there were residuals added, but the residuals were tied, were understood like we're just a small little player, Disney Plus, and we have very few.
Nobody watches Netflix.
Nobody watches. We have very few subscribers, and so they got deals where the residuals they paid were quite small compared to what writers, directors, and actors were getting in the traditional TV model. And then there was real resistance to, once there was sort of basically streaming dominates the market, takes off, to readjusting those residual payments. And in addition to those residual payments, there are also payments to pensions, not just for writers, actors, directors, but for other people, production designers, editors, et cetera, who don't get residuals. So pensions, healthcare, all of this was affected by the purported size and scope of the streaming services. So I think that background is important to understand. So with now the universal dominance of the streaming platforms, particularly in the wake of the pandemic, where, the theatrical model has really collapsed, the streaming services and revenue is much greater, and the sort of downside for writers and actors, et cetera, is much greater of not making sort of the residual payments more appropriate given the traffic on streaming services. And I'll talk about the writers in a moment, but there's also a competing problem, which is in the market from the other side, not the writer, directors, actors, but the businesses themselves are struggling, like particularly old content providers, the old studios who don't have streaming platforms. And there's so many different providers now in streaming platforms, then people aren't getting cable or satellite where you get all the channels, but you're also not going to pay like $19.99 a month for 30 different things. You're going to pick one or two. So this is a problem for the old studios in terms of not having streaming platforms of their own. I mean, Disney is an exception, but to distribute their content. And then there are too many streaming services and there's too much content. And so this is a big contrast with Amazon, who has Amazon Prime, and they're enjoying that. It's sort of a prestige thing, but it's not driving their business, right? If Amazon Prime Video disappeared overnight, Amazon would still be a behemoth and very profitable. And same thing with Apple, right? If we got rid of Apple content, video content, Apple would still be doing just fine selling their products. And so there are a lot of strange incentives in these new deals, which come up periodically, I think about every 3 years with the various unions. And so we have old content industries who are struggling and maybe merging. There's going to be a lot of changes over the next couple of years in these companies. Who are struggling. And then we have Amazon and Apple who don't really care about giving anything to the writers or actors or directors, because why would they? Financially, they don't need to. We have Netflix, which is all streaming, but also has a lot of back catalog, can film, say, in Korea and South Korea, which generating a lot of content for them and not have to worry about the unions. So there are lots of different players. So this is sort of the backdrop for the strike. So the writers and the actors both really wanted to focus on residuals and appropriate payments to pensions and healthcare on the basis of the dominance of the streaming services. The streaming services obviously didn't want to pay that, and the old school industries were more willing to. A second issue is AI for both. So writers were worried about the AI generation of scripts, which are not high quality, but could start things, might be more useful in the reality TV space, although the reality TV is not part of the writers' strike. And the actors also worried about AI-generated performances replacing real actors. This is especially true in background, although I say that all this discussion of generative AI is a little exaggerated in terms of the sea change, because there's already been very successful visual effects that could do a lot of background replacements. That's long-standing, and some replacements of performances already. But certainly it is a concern for actors and extras who are not as famous that they will just be replaced by AI, or that someone who does one performance could be replaced. This is unlikely to happen with celebrity star performers because customers probably, right, viewers probably won't like it. None of the studios or streaming services say they would have any interest in doing that. So those are the AI issues. The writers had a number of other really complicated issues, which is why it's lasted almost 150 days. And I think it's the second longest writer's strike ever, though they did reach, hopefully, agreement recently and will be voted on, I think, right now. Sometime later today will be approved by the Guild, and then it needs to be ratified by the members. I do know that the waiting period to work has been waived. Usually you have to wait for all the members to ratify, and it doesn't. So if they agree today, writers could potentially start within the next week writing. So those who are waiting for content, yay, writing's gonna come. But the writers also had, and the deal is not public yet, so I don't know, but the writers also had major concerns. Because again, going back to the old model, you used to staff a writer's room, you had a full complement of writers, they'd be there for the whole season, and there were about 24 episodes. And so people were paid substantially more for their work. Now we have, sort of high quality shows with only 8 to 10 episodes, many fewer episodes. If you're paid by the script, you're getting a lot less. The services don't want to pay for someone for the whole season. They might just want to pay for one script. And even though writers who work a whole season or executive producers are making a fair amount of money, if you're just selling one script on one show, no matter how fabulous and frequently watched, you're not going to be able to support yourself. And so that was another aspect that the writers were worried about. And at the same time, a lot of the contracts made the writers stay on call for the show that they were only being paid for one script. So they couldn't actually take even other work in some instances. So I assume that something was done about this, but I haven't seen the final deal there. So the actors next will be negotiating. I think that the residuals problem is likely going to track very much what the writers did, so it should be easy. I'm also told that some of the AI concerns are going to be addressed, but that some of them are likely going to be punted to Congress, which is the last thing I want to flag, which is that although there's not a lot of things being fast-tracked with regard to AI, there is currently something being considered involving what was originally called federal right of publicity laws, but maybe now tailored to digital replica performances. And it was raised in the congressional hearings on AI and copyright law, where they spent almost the entire time talking about rights of publicity. And this was driven largely by the Weekend Drake mashup that was generated by AI, and a concern that we'd be able to just have AI generate music, put it up on Spotify, and it would basically replace recording artists. As you can imagine, this made the recording industry very concerned. And sort of the Screen Actors Guild and the recording industry have joined forces and are trying to get Congress to pass very rapidly a digital replica, right? Which I'm happy to talk more about in Q&A, but it will take too long probably to go through it. But that some of the issues have been punted there, and there is not yet a draft bill, so I can't comment on its specifics. But I have concerns as well as some small degree of optimism.
May I ask you a terrible, reductive question? Who won the strike?
I think it's too early to say because I haven't seen how it's come out. I guess the writers, this was viewed as an existential crisis for the writers. And so to the extent that they got something that they're willing to accept, I view it as a victory for them because it was not sustainable. So I think that sets a significant, hope that writers will continue to be able to have a career that can support them. But I don't know the scope of it. I would be surprised if it was, overly generous. And it will certainly be renegotiated in a few more years. But hopefully it at least fixed sort of the out of whack low payments from streaming services.
Well, we'll go to our last speaker. Professor Dahl is going to talk about another trademark case, which is Elster.
Another First Amendment. We're back to First Amendment.
Do you want me to
I
come
have
on the
just a
screen?
few slides,
Okay,
so
you have
I'm
the
just going to
slides.
call them up because it's helpful to see some of the pictures so we can know what we're talking about. So give me just 1 second.
It's all right. Give any animations.
No.
Nope.
Just a couple slides to tee this up. Oh, thank you. Okay, so as we've been discussing, this is the third time in 6 years that SCOTUS has considered trademark registrability and clashes with the First Amendment. And I didn't imagine when I went into IP that I would have to go as much into First Amendment law as I had to in the last couple of years. But here we are back again with In Re Elster. This is kind of an interesting case. So it involves Section 1052 of the Lanham Act, which basically lays out registrability guidelines, and it specifically carves out a number of categories of marks that cannot be guaranteed federal registration for a variety of reasons. And we've heard in the last 6 years about 1052A in two places, where we had basically one case that took up a restriction on scandalous marks, which was the Iancu Brunetti FUCT case. And then we also talked about disparaging marks, which is Mittal v. Tam, which was the Slants case and also involved the Washington Redskins, at the time Redskins. Basically bubbled all the way up to the Supreme Court, and the Supreme Court in both cases struck down those parts of 1052A as being unconstitutional under the free speech clause of the First Amendment. And so now you can register so-called disparaging and scandalous, formerly disparaging and scandalous marks. Okay. So what's going on with Elster? So here's 1052 again, and this is the language of 1052. And when Elster began, it was actually about A and C. And now it's just about C. And we're gonna focus on that in a second. But basically, Mr. Elster wanted he wanted to register a mark that referenced this moment in the 2018 Republican presidential debates, where Marco Rubio accused Trump of having small hands. And of course, that was a euphemism. He was attacking him personally, and this is Trump, responding. And so Mr. Elster wanted to create T-shirts that made fun of this moment and in fact made fun of Trump. And so he decided that he wanted to register this mark, Trump Too Small. And if you see the back of the T-shirt, it's a little hard to see, but it basically says Trump's package is too small, small on the environment, small on civil rights, ... Okay, so then Mr. Elster wants to register this mark. And so he goes to the USPTO, and he applies for registration, and it is refused. And then he, as you do, appeals it to the TTAB, the Trademark Trial and Appeal Board, which affirms. And basically they say, under A and C, this mark, because it has the word Trump in it, both falsely suggests a connection with persons living or dead, and C, consists of or comprises a name without this person's written consent. So it gets refused. He appeals to TTAB. TTAB basically upholds the refusal and says, yes, indeed, by C, it comprises the name of Trump, and you did not get Trump's approval to do this. So now we're just focusing on C. But it is very much like the other cases where, there is a First Amendment element to this, because what Elster says is, hey, this is not just a mark, this is political criticism, because I am making a comment about my feelings about Trump, and I should be allowed to do this under the First Amendment. And so this goes all the way to the Federal Circuit, and the Federal Circuit reverses TTAB. Elster, you're right. Okay, this mark criticizes a public figure, so it is political speech. And 1052 actually, as applied to these facts, is unconstitutional because this restriction on political speech meets no level of scrutiny, and they refuse to say whether it should be intermediate scrutiny or strict scrutiny. So now it's come up before the Supreme Court. And here's the question that's presented. It's a pretty narrow question, but looking at 1052C, does this refusal to register this mark under this particular restriction violate the free speech cause of the First Amendment? And specifically, we're not looking at just any name, but we're looking at when this is a government official or a public figure and you're criticizing them. So this is the question that is before the Supreme Court. There are a lot of interesting things in this case, and I wish that we had an hour to unpack all of them. But I think one of the most interesting things that I've been thinking about is let's say that Mr. Elster does get the ability to register this mark because he has the ability, should have the ability, and the government should not stop him from criticizing a political figure. Now he has a right to control that mark in a commercial setting and exclude other people. So is that in effect keeping other people from printing T-shirts with something that says Trump too small? And are we then getting in the way of other people basically being able to criticize a public figure? So that's one sort of interesting thing that I think. This was also what we call a 1B trademark application, so it wasn't in commerce yet, but I'm assuming he's selling these T-shirts at this point, so it should be a 1A. I'm not sure if he's using this mark as a trademark, frankly, because it's just a comment on a T-shirt. A trademark is supposed to be a source identifier. It's supposed to be branding. And although he's gotten kind of famous because of this case, I don't know if what he's actually doing with this Trump too small is defining, a line of T-shirts. Right? You can see the difference between what he's doing and what like Nike does when they sort of have a whole range of products. This is just something written on a T-shirt.
I assume
So that's
the
a question.
goods he's saying he's associating with is just T-shirts.
25, class 25 for clothing.
Clothing.
His main mission, I've actually communicated with Steve Elster, but his main mission.
We should have him in for a
That would be fun. You would love to do that.
Yeah.
He is, I would say, politically motivated. He is not an apparel vendor. And so, but I find this case, I was really surprised that the court took this case in its current framing and disappointed. Because I don't think the Federal Circuit's decision was correct, but I thought the Supreme Court would have waited since it was an ITU till sort of further.
Intent to use.
Right, the intent to use, that's the 2B. Because I think, as Cindy mentioned, there's a failure to function problem. Just putting a slogan on a shirt is not a source identifier. And so this case seems to me about just a political T-shirt. And so you can have your trademark registration rejected here. He can still sell T-shirts that say Trump too small to anyone who wants to buy one. He can wear one. We could all wear them. And there's no problem with that. So he doesn't need the registration. So as Cindy mentioned, right, if he gets the registration, he could potentially stop others. So that's a problem. And also we circle back to Jack Daniels, which is the Supreme Court, having taken this case, is just going to reverse the Federal Circuit. Like, I'm willing to bet on this. So I don't know. I'll buy everyone a beer if I'm wrong.
How about a T-shirt? Everybody buy a T-shirt.
Wait, what about the tarnishment argument here that you made in the Jack Daniels context?
So the bottom line is Trump has a mark and Trump sells all sorts of things.
Yeah.
Trump is a seller of wares, and so his mark is going to be deemed valuable. So that means that, right, the Lanham Act Section 2C or 1052C is going to be upheld as constitutional. As applied here, if they're rejecting it because it's a political statement, that would be unconstitutional. But if they're rejecting it because it's using someone else's name as a mark, that's going to be constitutional. I think that's how they're going to interpret it. But the reason I'm disappointed they're taking it is because it suggests or lends a patina of legitimacy to claiming that these sorts of slogans and catchphrases on T-shirts are actually functioning as marks. And there's lots of things that people are trying to register, and some of which they've successfully registered, that are just slogans and really should be free for everyone to use.
So why isn't there opposition, because it's dilutive of another mark, that's another ground to oppose? Why is that, you're saying that, as you said, there are a lot of products that,
It could
commercializes everything, so.
It could dilute. Trump didn't oppose this, so but the
and the way that
Yeah.
the lower
Yeah.
the TTAB and the federal circuit framed it didn't.
Yeah.
That's really not.
But
an issue.
there could be another.
But sure.
Yeah, there could be a lawsuit right away.
The other reason I don't like it because it didn't tee up the 2A issue, or the 1052A issue, which is the false suggestion of a connection, because that allows to prohibit the registration short of confusion, but if there's some connect, like consumers would think it was representing Trump, which it clearly is. So the fact that they're bifurcated in this case means that even the Supreme Court rules on 2C, we're still gonna have to litigate about 2A.
Maybe the best way is not to have it trademarked, and then everyone could just issue such shirts or other articles with the same slogan. I don't know.
But they can, that's the thing, they just
they can
can't.
now, but then not if it gets trademarked, right?
So at this moment, I'd like to wrap this up and move to the audience. In the last 13 minutes we have, if there's any questions you have about any things we talked about, or frankly, I think anything coming up in the law is fair game.
Yeah.
Please.
I guess I'm curious, going back to the first thing we talked about with the Andy Warhol case, I know in copyright we talked a little bit about the Obama Hope poster and taking that photo from another photographer without the licensing. I'm curious, if that case had happened today after this Warhol case, would that have, I guess, meant the court would have ruled us in a similar manner to that, or is it a separate issue, I guess?
I think it's a great question, and it goes back to what Jennifer said. I mean, if you limit it to the facts, and it's like, but it's true that both are. It's a real great question. I will try to answer it in class when we get to that. But I will.
We're all gonna have
To me,
the poster was more transformative. The purpose was different, and if I were sitting in judgment, but I will not be, I would have ruled that the poster was fair use. I don't know, Jennifer, what's your
I'm not sure you can make a distinction between the ultimate derivative works in each instance, between the Warhol and the Shepard Fairey. Those seem similar, but I think Gideon's right that the way in which it's used was different and not substitutionary. I would be surprised if it came out the same way as the Warhol litigation.
So there's agreement here. That's great.
Dissent?
Yeah,
Anyone?
Why?
I mean, it just, again, as we talked about when we talked about Warhol, really depends on how seriously they are taking, the chain. I mean, whether we really do think it's that the Warhol case is limited to that set of substitution facts, because if it's not, then that's a pretty big, right?
Yeah.
And then all bets are off,
Just
right?
to play devil's advocate, right? If we're just flipping the other side, now my students in any of my classes are like, "That's Professor Rothman. She always switches sides." But right, the other side is it's the photographer. Like, we know who the photographer was. It was a working photographer who, like Goldsmith, makes money by licensing photographs to illustrate stories and posters of their work, and so they're losing out on licensing money. And why shouldn't they get paid for that derivative use of their work? So I actually think it could go either way, but I do think it is distinguishable on the facts from the Goldsmith case.
But
I can distinguish further, but I want another question.
You're getting it whether it's 1 or 4, and you're suggesting they might push the same direction, actually. So it's interesting. Other questions? Please.
I have a question about the writer's strike, the stuff that's going on with that. Can you just talk a little bit about who the parties to these contracts in the media are? Because it's like, I understand when, Netflix makes their own show, there can be a contract between the writers and Netflix. But what about, can you just talk about the flow down of the parties to all these contracts and how they're all related?
Yeah, so they're called a contract, but they're collective bargaining agreements. So these are unions. So there's the Writers Guild of America, the Screen Actors Guild, which merged with the, I think, American Federation of Theater Actors, so it's now SAG-AFTRA. There's the Directors Guild of America. So these are all unions, and they have collective bargaining agreements with the producers. And the producers also have like a collective umbrella. So they all sign on to these collective bargaining agreements with the unions. That's sort of the situation.
And the CBAs define then what these contracts can look like.
Right, and they require the collective bargaining agreements say they govern what individual contracts with individual writers, directors, and actors look like, and they also mandate residual payments that are tied that aren't individually negotiated in employee contracts. And what has, like, in the pre-streaming world, we had a number of studios and distributors, and they were all the producers, and they all knew one another, and they all had the same sort of objectives and challenges. So it was much easier to negotiate with the group of writers. Now, because we have the streaming parties, we have the Apple, the Amazon, and they have different interests than Netflix, and Netflix has different interests than Universal and Warner Brothers and Disney. All of a sudden, the producers who used to largely be on the same page were not on the same page in these negotiations. And that's really why it has taken so long to resolve.
But don't you have then smaller production companies who then license their stuff to Netflix? So are you...
Right, but then they may not be, there are some productions that are outside the union system, but if you are doing a union job, then you have to adhere to whatever the overall collective bargaining agreement was, even if you were not expressly signatory. Like the Producers Guild will agree to it and all the different companies.
So even those smaller production companies are likely to fall, in most cases, underneath the collective bargaining agreement.
Right, I think about like Ron Howard and some of these people who have like, or Plan B Productions.
Yeah. They would all be governed by that.
I mean, I think,
They'd all
to
be
get back to
governed
this
by the-
point, I think what you can't sort of underestimate is the magnitude of the different market that there is now, right? I mean, now that these tech companies have gotten into the streaming game, are now major consumers of production and writing and stuff, has really changed because as you noted earlier, their incentives are quite different, right? I mean, Apple and Amazon don't really care, right? Whether or not they make a ton of money on streaming. They are trying to suck people into their platforms, right?
But they are investing a lot more in content than we saw before.
A lot.
So I mean, that's the other part.
And they have different interests than everybody else.
Right, it's prestige. That feels like, yeah.
Please.
Going back to the discussion about FTC's complaint about Amazon, Professor Havenkamp mentioned that they could make some motions to break up, but they didn't. Is there an avenue for the FTC to maybe argue that AWS needs to be broken out because its margins so much higher that it's subsidizing kind of the anti-competitive behavior that goes on with Amazon Prime?
It's not made in this complaint, and I don't know what the answer would be. These cross-subsidization arguments almost never work, which is not to say they could never work, but that has been a big issue for Lena Khan for as long as she's been writing, but it almost always fails. I mean, she's got the idea that she wrote this up in a different piece about conflicts between selling one's own goods and selling competitors' goods, and she would like to have them segregated. So Amazon would have a choice to either sell its own stuff or to sell stuff for third parties, but you can't do both on the same website. Well, I think that's a misunderstanding of how competition works. Multi-product sellers always sell their own goods and the goods of other parties. Netflix.
I mean, store brands have been around
Store
forever,
brands have
right?
been around since the 30s, and Netflix showing its own films on the same website as its licensed films is a very common thing. And, we generally think it increases output to do that because you can aggregate things from both parties across, and the leverage argument just never acquires any empirical support.
So if I may, you have the ability to, if you make money on one market, to lose it in another one, but what's your incentive? I make a lot of money. I throw a match, put gasoline, throw a match on it. I can do that. Why would I? Unless there's a credible reason you can actually make that other mark, you can make more money the other marker.
Right, so the argument, the AWS argument would be that they're cross-subsidizing, by using the profits from Amazon.com to essentially make it impossible for anyone else to build out sort of server infrastructure companies.
Those arguments have some legitimacy in public utility law
Yes.
because one of the prices is regulated. And then you do get a problem of cross-subsidization because you can sneak in products if the regulated price is artificially high, or you can sneak them out if it's artificially low. But where all the prices are set by markets, those cross-subsidy arguments really don't get you anywhere.
So first of all, thank you for a very interesting discussion. I had a question, Professor Ratman, that you seem to be skeptical that the sort of fears about AI in terms of the actors and the writers are real. And I sort of agree with you on some of the writing stuff. It's just not that good. But I think just taking the example of people who do voice acting and stuff like that, the ability now to sort of record someone and then use their, reuse their voice for, I don't know if you're getting those, I'm getting those commercials on Instagram all the time. Snoop Dogg will read your high school, like your stuff. And I've tried some of those apps and it's very good. You can have Snoop Dogg read.
Right, I was not suggesting that I didn't think it was concerning. I was discussing two things. One, with regard to the writers, that AI is not there yet. I don't know if it will be. I hold out hope for humanity that there's a spark of human touch that will protect creative expression from AI, though I fear it won't. But currently, the AI generated writing is not good enough to replace human writers. So I'm not saying it never will be. I'm saying it's not currently. In acting, it's better. You're right with like the recording artists who you don't see. The voice stuff is pretty good. Some of the performances are also decent, depending.
In 3 years, I'll be Donald Duck.
Right. So, no, I think those are very real concerns and need to be addressed. There are already a number of laws on the books that address those sorts of things. So they need to be enforced and litigated, and there may be additional federal legislation. So I do think that's worth worrying about. My point with regard to actors was that the concern of actors of being replaced or their performances being replaced is not new to 2023. There's been litigation about reconstructed performances using previously copyrighted work since at least the 1980s. And the visual effects have been good enough to do that in some small ways for at least a decade. So I'm just saying it's not novel to 2023. It's just the technology is getting better and better and faster and faster.
Well, I think that hope for humanity is a great note to end this event.
Yes.
Please join me in thanking the speakers for coming in.
I was just gonna say, we're hoping to find a date in November for a full session on the strikes.
And for those of you who are interested, we'll do something on the strikes. And by the way, the FCC announced today that they're going to revive network neutrality. So you heard it here. I mean, it's all turning along.
We're all gonna be busy.
Keeping you busy, yeah.